Good morning, everyone. Welcome to our June webinar on DEI again, but it seems to be a popular topic that's in the news. It's a beautiful day out, so if you decide that you'd rather go enjoy the day and the sunshine, we do record these webinars, just so you know, and we do post them to our website within 24 hours, and we send out the SHRM code and all of that good stuff. So if something comes up and you'd rather do something else, just know that that's available to you. We do have all lines muted during this, but if you look at the Q&A box, I'm really a very casual speaker and I take questions as we go. So feel free to submit a question and we'll try to get them answered. We always look for new ideas for webinars as well. So if you have anything, please let us know. In July and August, we will have webinars on the FLSA because that seems to be a topic that, not surprisingly, is very popular and causes a lot of confusion for people. And we're also going to talk about handbooks and some errors that we're seeing there. So those are coming up in July and August. And then, of course, in September, we'll have cocktails and compliance. The date isn't quite set for that, but that is always a fun one. So keep that on lookout for that. All right. I think most of you know me. I'm Ann Lavelle. I'm CTR's compliance specialist. For those of you who don't know me, my prior life involved almost a quarter of a century as a partner in a very large firm downtown where we did exclusively, the group I was in, we did exclusively management side labor and employment law, meaning we only ever defended companies and handled the full range of what I call alphabet soup. So anything that had an acronym under the law is pretty much what we handled, whether that was FMLA or ACA or FLSA or whatever you want to call it. So I did retire to spend some more time with my family, but I always enjoyed the educational component of things and liked doing trainings for employers. And so this is a fun opportunity to be able to hopefully share some knowledge and have a good discussion on different topics. We do these webinars once a month. There is SHRM credit for it. It is typically the second Thursday of the month. So feel free to, join whenever you can. And the way we set these up typically is usually in the 30 days since we've last met, either the courts or the legislature or the government or somebody has done something that's worth reporting on. And so we usually set this up as a little update first on anything that's important, and then we talk about our main topic. And we do have a really important update. It's an agency update this time. We'll talk about that in a second. It's actually, in my view, more important than the actual topic we have today because it's a landmark change. All right. And again, all this will be sent out, all the slides. I don't do that part because I mess up technology. So other folks will send this out to you and we'll go from there. And again, feel free to ask questions. So what is the little update for today? It's an agency update. And you may recall, if you've been a longtime participant in some of these webinars, that maybe 6 months ago, we had talked about the fact that the EEOC had issued a statement. Now, the EEOC is the Equal Employment Opportunity Commission, and they're in charge of handling discrimination and harassment and similar claims like that. They had issued a statement that said they were no longer going to handle or enforce what we call disparate impact cases, that they were only going to go for what we would call direct discrimination. In other words, cases that say, hey, I was terminated or I was disciplined or whatever because, and I always pick on myself, I'm over 40. I know you're surprised. Or whatever it might be, or I'm female or whatever. We're not going to go for disparate impact cases anymore. That was a huge, huge departure from past practice. So we have an update to that now. They're digging their heels in even more on this. And so let's talk for a second about what disparate impact is, because that was always a very difficult type of case to defend. So a disparate impact discrimination case says, hey, you can have an employer who has a facially neutral policy of some type, but it has a disparate impact against protected groups. So, for instance, I could say, I want everybody to have a high school diploma that I hire. That's a facially neutral policy or practice or requirement, whatever you want to call it. And it's a very common one, right? There's no necessarily discriminatory intent behind saying, I want all of my candidates to have a high school diploma, or I want them to be able to pass a basic math test because we're carpenters and you need to be able to measure and cut the wood correctly. All that's facially neutral. But it has a disparate impact because we know statistically that some minorities are less likely to have a high school diploma than folks of the majority group. Okay, so I'm more likely as a white person to have a high school diploma than somebody who might be African American. And so, what you would see with some of these facially neutral policies, even though there was no intent to discriminate, is that it would negatively impact minorities or women or ethnicities, whatever protected class you want to look at. And so you'd have, say, a facially neutral policy or test that you have to have a high school diploma, or you have to be able to pass a basic math test or a basic intelligence test or something in order to get the job. And if we looked at the candidate pool, and I'm just making up numbers, let's say there's 100 candidates and proportionately 95% of the white folks could meet those requirements, but proportionately only 75% of the minorities could meet those requirements. That's disparate impact, right? It affects the minorities more than it affects the majority. And that would lead to a discrimination claim that was very tough for employers, because employers would say, hey, I'm not trying to discriminate. I think this policy is legitimately tied to my business needs. My carpenters have to be able to measure and cut and whatever. And I can't help that my business requirements are negatively impacting minorities. And a lot of the courts would disagree and say, no, it's disparate impact. We don't care about your intent. Come up with a new policy that doesn't have, or a new test that doesn't have disparate impact. This started, and I'm sure you all wanted a history lesson today, in the 1960s, because there's a famous Supreme Court case involving the Duke Power Company out of North Carolina. What did we have in the 1960s? In 1964, we had Title VII, right? And I know everybody on this webinar knows Title VII. That was the major anti-discrimination, anti-harassment law of the civil rights movement back then. And so Duke Power Company got crafty and they said, okay, we can't discriminate in our hiring anymore. We can't just say all of the minorities get the really crappy jobs, excuse my language, in the areas of the power plant that are kind of hot and bad and there's no potential for promotion. That's what they were doing. Now they can't do that. So Duke Power Company got crafty and said, okay, we're in the deep South, sort of, and we're going to instead make requirements that we never had before. That you have to have a high school diploma and you have to pass certain written and intelligence and other proficiency tests in order to have what were perceived to be the plum assignments within the power company. And again, that's facially neutral, right? You have to have a high school diploma, you have to have a certain ability to do math or whatever to have the better jobs within the power plant. And that case wound its way up. Again, this is 1965, 1966, clear up to the Supreme Court. And the Supreme Court said, no, that is just code for discrimination. That's disparate impact. We find that disparate impact is impermissible. That's the history behind this, a Supreme Court decision from the mid 1960s, based on what Duke is called Griggs versus Duke Power. If anybody is really bored and wants some reading material, that's what that stood for. So fast forward to today, which is, more than 50 years later, and the Department of Justice this week issued a memo saying, hey, we think disparate impact is actually that legal theory is unconstitutional and actually results in companies discriminating at this point in our culture in favor of minorities and against the majority when you have a facially neutral policy, but you can't implement it because of the disparate impact liability. So we've done a 180. In other words, the DOJ, the Department of Justice, issued a memo to the EEOC, so two government agencies, telling the EEOC that it agreed with its stance that it's stopping enforcement of disparate impact cases, and in fact, going a step further and saying, hey, disparate impact cases actually can show racial or ethnic or gender or whatever inequality against the majority. You can actually have a situation that because you don't enforce your facially neutral policy, you're discriminating against the majority unintentionally, and it's unconstitutional. Where does this leave us? And you're probably like, I thought I tuned in for DEI, not a history lesson on Title VII. Yes, you did. But this is really important. So where does this leave us? We have a federal agency that won't enforce this anymore. This is undoubtedly going to weave its way through the courts. If we have facially neutral policies, we have a really strong basis now for continuing to use those, even if they inadvertently discriminate or have an adverse impact against minorities. Having said that, I think ethically, and because there's legal uncertainty here, any policy we have, any requirement to be hired or promoted or whatever, ought to make sense for our business, right? And so if we're carpenters, it matters a lot that we can do math. If we are an attorney, it might not matter if we can do math. Not that I would know that. And so we still should have a legitimate, non-discriminatory business rationale why we have any facially neutral policy, hiring requirement, testing, whatever it might be, to be in our company or promoted within our company. However, we should also, as employers, perhaps have a sigh of relief that if we are doing this, and it makes sense what we're doing, right? That we have a business reason for doing this, and it's facially neutral, and we're not trying to discriminate. There's no intent here. It just statistically is not a good outcome for certain protected classes. We actually have legal support now for what we're doing. And that can help you if you're trying to defend a case like this. Where do we have some complexities? Do all the states agree with the DOJ and the EEOC? We don't know yet because this just came out this week, but I strongly suspect that Pennsylvania will not agree with this because they don't agree with any of, and I try to stay apolitical in all things, but the reality is we've got a Democratic blue state, right? And they don't agree with some of the more conservative Republican red type of ideas coming out of the federal government. So I suspect that we will still see disparate impact concerns in the state of Pennsylvania, but not in the conservative red states, if that makes sense, at least until we have a new administration, either at the federal or state level. So this is, in my view, groundbreaking. I don't know that I'd say earth-shattering, but something to really be aware of if you're in the HR field, because even if your current company doesn't do this, if you move around, somebody will. All right, let's dive into what you all came for, which was DEI. And what's the legal backdrop to DEI? Why should you care? Well, it's the law. usually a good idea to follow the law. And because there's competing liability in many forms when we're looking at DEI, we have the employee involved who might be in the protected group. We have the employees who are not in the protected group who have rights. We have federal law. We have state law. We have local law. For those of you lucky enough or unlucky enough, depending on how you view life, to be in Allegheny County or the city of Pittsburgh, not only do you have the leave laws that we've talked about a million times, but they both have their own commissions that handle discrimination or harassment claims. So when you have an employee or a company in Allegheny County or city of Pittsburgh, they have a choice. They can go to the EEOC, which is the federal folks, the state folks, which are the Pennsylvania Human Relations Commission, the PHRC, or they can go to the Allegheny County Commission or the Pittsburgh one with their complaints and concerns. And remember, it's wherever the worker is working, not where you're located. So if the worker is in North Dakota or California or Texas, you're going to have very different commissions and very different viewpoints by those commissions, depending on whether the state is red or blue. So moving on, what's the biggest flashpoint? Okay, so I want to address this because somebody just brought this up. So it said, interesting. On Monday, SHRM downplayed that the EEOC's national enforcement plan said about disparate impact. The author of their online summary said that while the EEOC acknowledged that disparate impact liability is part of federal law, they will simply minimize disparate impact theories and seek to minimize reliance on disparate impact whenever possible. So to a certain extent, I agree with that, but I think I still view this as groundbreaking. So I've got a difference of opinion compared to whoever that SHRM commentator was. And on Monday, I don't know if the DOJ memo was factored into whoever talked on Monday, because that came out this week. That might change their opinion if they had not seen that memo or hadn't read it prior to whatever the thing was on Monday. And I don't know. But to me, to have a Department of Justice memo directing the EEOC to do something, I think is groundbreaking in terms of that was a liability theory that has sort of gone poof with respect to it. So now if you are a company and you have an employee suing you, that employee has to show intent. And that's a big change. From, okay, so he said, sorry for the typo, they will maximize disparate treatment and minimize disparate impact. Thank you for correcting the typo. I was a little confused, but then I'm often confused, so I was okay with it. So I don't know if they saw the DOJ memo because that came out this week, and if they published that on Monday, I just don't know if they saw it. But that's a very unusual scenario. But the only aspect they have now for the EEOC to proceed on a case is the disparate treatment. They have to show intent that I, as a company, disciplined Ann Lavelle because she's female and she's over 40 and she has a history of being on FMLA leave and being pregnant and whatever, as opposed to, and that can be a heavy burden for a plaintiff to meet, to show that that was the motivating factor in my termination or my discipline or failure to hire or whatever it is. Statistically, that's a very different way to show things, right? Intent is very subjective. Statistics are objective. Intent, disparate treatment can be tougher to show. So I still view that as a landmark change because it changes how the plaintiff's bar has to approach cases. It changes how the level, the burden they have to show that there's intent in terms of discrimination. And it changes a whole theory, basically went out the window for the plaintiff's bar. So difference of opinion. Again, I'd be curious to know if you know whether that SHRM content was pre or post the DOJ memo, just out of curiosity. Okay, thanks for bringing that up. I always like to see a different viewpoint too. So feel free. Okay, so what's the biggest flashpoint that we have out there? Okay, somebody has raised their hand. I can't actually just put any question you have in the Q&A, and I'm happy to answer those. And if we run out of time, I will stay as long as we need to answer questions. Okay, so transgender issues, without a doubt, that's our biggest flashpoint. And again, I try to stay apolitical in all things. I also try to be kind in all things because I think that's really important just for my own ethics in my own life. So we've talked about this before. We talked about it at the seminar we had. We talked about it in prior webinars. We have an EEOC ruling within their own departmental agencies saying that access to the bathroom based on biological sex does not violate Title VII. Of course, that's being appealed. Of course, that's going to go up the rungs of the court, but that's the EEOC position. So remember, we said employees can pick what agency they want to go to. And if you're in a blue state like we are, what do you think the PHRC is going to say about this? They're not going to be in alignment necessarily, and we'll talk about that in a second, with the EEOC opinion, which puts employers in a really, really difficult position if you're in a blue state. If you're in a red state, it's not as important, right? If you're in West Virginia, which has followed in the footsteps, more or less, of the federal government position on transgender issues, maybe you don't have that conflict and that concern that folks in Pennsylvania would. So we also recently had this month, or past month, the Department of Defense. They're attempting to eliminate all transgender military folks. And a divided, back in May a year ago, the Supreme Court said, yes, we can stop new recruits. We can't stop current members who are transgender in the military, even though President Trump had tried to ban all of it. We had the Supreme Court said that has to work its way out through the lower courts first. So we had the DC, as in Washington, DC, District Court ruled 2-1 about 10 days ago that essentially, and it was along party lines, depending on which president had nominated the judge. There was 2 Democratic nominated judges and 1 Republican nominated judge, said, hey, current transgender members of the military can't be removed, but we can bar new transgender recruits. Where is this case going? SCOTUS, of course, right? The Supreme Court. So that's going to work its way up. But that also shows that even among Democratic appointed judges, there is traction at this point to limit some transgender rights or requests, however you want to look at them, with respect to that. All right, where's Pennsylvania? Since the vast majority of you are in Pennsylvania, we're 180. So if the employee files at the Pennsylvania Human Relations Commission or Allegheny County or Pittsburgh, or if you're in Philadelphia, they have one too. We have our own gender transition guidelines that were issued in 2023. They address pretty much any issue that a transgender person might have, including bathrooms, locker rooms, pronouns, hiring, medical leave, anything along those lines. And I have cut and paste the exact language from these guidelines below, and you can see that essentially the position of these guidelines issued by the PHRC, by the state here, that their guidance is the person should be able to use the restroom or the locker facility or whatever that's in alignment with their gender identity. And it also goes on to talk about we have to use the pronouns that they want, that they feel that matches them, and folks who are non-binary or who are in the middle of transitioning get to choose essentially which restroom, which locker room facility, which pronouns, whatever that they want. does that gel with the current federal law? No, it doesn't at all, right? And these have not been revoked or rescinded, as opposed to some of the EEOC guidance on this, which was rescinded when President Trump came into office. So where does this leave you? First, and I harp on this all of the time, which is insurance, insurance, insurance. You can't afford to be sued. And if you're put into the situation, because everybody has rights, both the transgender person has rights as well as the non-transgender person, right? They both have rights and they both have arguments. And this is a real conundrum right at the moment because we don't have clear guidance. If I am the non-transgender person and I object to the transgender person being in the ladies' bathroom with me or locker room or wherever, or maybe I have a religious viewpoint that I am not going to use pronouns that I don't believe are applicable to the transgender person. You have a tension between my rights and the transgender person's rights. And in Pennsylvania, you really can't win because if that person, the transgender person, is going to go to the agency that is transgender friendly, and I'm going to go as a non-transgender person to the agency that's friendly to me in terms of my viewpoints. And so you end up with a powder keg essentially that you can't win on because you can't comply with both laws at the same time. Insurance, employment practices, liability insurance. You can't afford this type of litigation. You don't want to afford this type of litigation. That's your safety net. So in all things, with discrimination or harassment, that's what you want. Counsel. If I were the employer and I had one of these situations brewing in my workplace, I would be on the phone with that attorney who specializes in labor and employment law. And I think that's really important. Whether you're on the employee side of things or the employer side of things, you don't want a general practitioner on something that is this much of a powder keg. You're looking for somebody, even though they're more expensive, who has that expertise in labor and employment law. That should be what they do. And ideally, you want somebody, and I don't practice anymore, so I don't have any dog in this fight, and I love dogs. I wouldn't want to see them fight. You want somebody who does, if you're the employer, the management side only, because that makes all of their positions consistent with the courts. And conversely, if you're on the employee side, you want somebody who's doing only the plaintiff bar work. So I would be lawyering up because this is such a powder keg. This is where your money is well spent, and an ounce of prevention is worth a pound of cure if you have one of these situations brewing. There's some things that I think, okay, if you want to buy the $25 handbook online, it's not a great option, but it's not horrible. Handling this on your own, I do think, is a horrible option. And I would watch the Supreme Court. We're going to have a decision soon on this. And we've talked about the sports cases that are up there right now. Those might be for high school or college sports, but the impact is going to have a trickle-down effect. So you want to watch that. But in the meantime, there's no silver bullet. There's insurance and there's counsel and there's watching the Supreme Court. Okay. Isn't that good news for today? All right. And of course, the other thing that I would consider, and this may be for the benefits folks out there, we've seen numerous pediatric transgender treatment settlements, both on an individual level and on a healthcare system-wide level, essentially saying, hey, the transgender treatment provided to me was inappropriate. Now I want to detransition. The medical folks didn't look long enough, hard enough, whatever, at my particular situation and treated me inappropriately. It was basically malpractice. There's been several of those cases. Most recently, within the past week, we had the Cleveland Clinic that agreed to a 20-year ban on transgender pediatric treatment. along with committing 2 million to detransitioning and paying roughly 300,000 in penalties for falsification of billing with respect to transgender treatment. Why do you care? Other than maybe you're interested in this issue? Well, I would start thinking, if I was proactive, what does my health plan look like? And I think at this point, particularly in the blue states, you're kind of stuck because the blue states are going to have some input into this, even though health plans are generally governed by federal law as to what can and can't be covered. But I think this is a likely trickle down effect into health plans and what they will or won't be required to cover, as well as a lot of folks have flexible spending accounts, which are by definition self-funded health plans. And I'll get on my soapbox for just a second about those, because that was just something I saw come up a lot when I practiced, is folks didn't realize, employers didn't realize, when you have a self-funded health plan, all of the ERISA bells and whistles, if you're an ERISA employer, and most companies are, unless you're nonprofit or government or religious employer, are covered by ERISA. And so if you have a flexible spending account, which is a self-funded health plan, you have a lot of ERISA obligations, and you need to keep better track of it than your perhaps fully insured health plan and what it's paying. And so this is just something that, when you renew, I would start asking, like, where are we on this? Are we okay? Do we comply with both state and federal law on this? And again, it's mainly going to be federal law that they're looking at, because I think we're going to see this trickle down in terms of what's being paid for, what can be paid for, and whether there is any violation of the law for paying for these types of transgender pediatric treatments. So something to keep in mind, something to look at, particularly as you renew. Okay, moving on from the biggest flashpoint, which is the transgender concerns. Everyone needs a mentor, right? I'm a huge fan of mentoring. And so everybody needs a mentor. And certainly at the firm I worked for, I was on the hiring committee. I was on the new associates committee, because I love doing that type of stuff. I love trying to help. You graduate from law school, graduate from college, whatever your career is, and you know enough to be dangerous, probably. And so I love trying to help new associates come in or whatever. Everyone, though, now means everyone. So if we have a mentoring program of any kind, certainly a formal one, but even an informal one could be of concern. We can't just say, hey, we have a mentoring program for protected groups, right? We can't just have the mentoring program be for folks who are minorities or for folks who are female. We now have to have that program open to anybody who might want a mentor, right? Maybe some people don't. I don't know. We've got to go against what has historically been the trend, is that oftentimes we paired up mentors with somebody in the same protected group, right? So with the thought process being that, well, hey, Anne's female and she's had a few kids, they're running amok somewhere, we're going to put another female associate, maybe that person has kids too, with Anne, so they can talk about whatever obstacles, challenge, whatever are consistent among both of them. We can't make that type of specific pairing. Hopefully Anne and that person find each other within the workplace and can talk and whatever, but our mentoring program should be blind with respect to gender and race and ethnicity and religion and anything else that might be out there. What about networking? So that's a great question. And the EEOC a couple months ago took on a Coca-Cola bottler out west that had a women's only networking event. I think we don't have a decision there. That's sort of being duked out at this point. But that shows you where the EEOC is going with this. It's saying you cannot have a networking event that's open to just one protected class. If anybody can attend the networking event, great, that's fantastic. But just having the networking event be open to women, which was what this was for this Coca-Cola bottler, is inappropriate. That's the EEOC stance. And that's 180 from what prior practice tended to be for organizations. Because the idea was, well, hey, women historically or minorities historically didn't have as many networking opportunities, so we're going to create these opportunities specifically for them. Oh dear, my computer has decided that it's doing its own thing all of a sudden. I don't know. I think we had like a little power glitch here, and it decided to turn off for a second. So I hope you guys still have me. Okay, it looks like I'm still on. That's a concern. So as the law stands right now at a federal level, I think you need to make sure your networking and other similar activities are open to everybody. What about non-employer sponsored professional groups? I want to join the Women's Law Association. Is that okay? I think that really depends. You can't stop me from doing it, right? But if you're funding it, if you're funding Ann Lavelle wants to join the female salespersons group of Pennsylvania, then I think you need to be cognizant that you're also funding similar opportunities for others, or saying to Ann, you know what, knock yourself out if you want to go join that organization, but you're not doing it with the company dime or on company time or whatever it might be, unless we can somehow provide the equivalent to others. I think that's something to be concerned about. And take a look at what you do fund and what you don't fund. All right, moving on. So everybody needs to belong. I think we've covered this in other things, but it's worth talking about. Affinity groups, right? I make the joke, and I make this in part because those of you who know me know I have some adopted children who are not the same race or ethnicity as I am. And so one of them happens to be Hispanic. So I tend to make jokes about Taco Tuesday or something. If I want to join the Hispanic law group, can I do that? I'm not Hispanic, right? But I might really have a vested interest in that because one of my children is Hispanic. That may be something I'm really passionate about, or I could just be the jerk who wants to be there for Taco Tuesday and really is just there to eat the tacos. At this point, you really have to open those affinity groups to whoever has a legitimate interest in being in it and who isn't disruptive or causing a problem. Take this one step further, and this was always a tough issue in terms of discrimination claims. We would get a claim that said, hey, I was discriminated against. And you could just see it because they would never invite me to lunch. They wouldn't invite me to dinner. They wouldn't invite me to cocktails or whatever it is, happy hour type of stuff. I think if you have groups going out that are sponsored by the employer, right? And sponsoring doesn't necessarily mean on the employer's dime. It can be we use the employer's email system to send an invite. You have to be thoughtful about what you're allowing there if they are excluding or limiting who can go out on these little group outings. Because sponsorship includes not just something that's on the company's dime, but also something that is using their email systems, their bulletin boards, whatever it is to promote this activity. All right, everybody wants to succeed, I think. Any type of incentive, awards, scholarships. We used to do this at the firm that I was in. We would give minority scholarships. I think that's a problem at this point, at least under federal law. And there was reasons we did it, right? The idea that past discrimination and practices made it more difficult for minorities to break into certain professions. And so we were giving them a monetary incentive to come join us. I think those are all problematic now. And I think those need to be open to whoever, at least on a federal level, you're going to have problems with it. What does that mean for the workplace? Well, it still has to be discrimination free, right? You still have to do the required anti-discrimination, anti-harassment training, whether that's live, in person, whether that's video, whatever you have. you really should be doing that on a yearly basis. But what I would encourage you, because the cases are now going to, attacking training that perhaps has reverse biases in it. And so if you're using canned training, which there's nothing wrong with that, you've got the videotape, or show my age saying videotape, but the electronic training, you want to make sure that that training is not problematic, that you're going to get a reverse discrimination claim or hostile work environment claim because of the training, right? The whole point of the training is we don't want discrimination. We don't want harassment. We want a workplace that's appropriate for everybody. The training comes under attack when it has perhaps what people perceive to be attacks against the majority, saying, hey, there's inherent bias, there's inherent historical problems with white people, whatever it might be. That's what you want to look for to say, is that relevant enough to include in the training in my organization, or am I better off just sticking with don't discriminate, don't harass people? At this point, I think you're better off sticking with that, given where the federal law is at this juncture. But you still need to do it. You should do it every year. Have folks sign off on it that they've done it. In a defensive posture, I want to be able to show that my client, when I practiced, had trained its employees and had done it well, and had done it with training that was modern, not something you obtained 20 years ago in the early 2000s, something that is relevant today and up to date. Also, some people have asked, is it better to have live training versus a videotape? I want to see you do something. Live training can be really expensive, and I personally would not invest in that unless I had a problem in the organization. And that's usually when I came in to do training, was if we thought there was a problem going on and we had concerns. And perhaps we wanted to see if people would ask questions so that we could maybe get a better handle on where the concerns were. You send in somebody live to do it, who has the experience to handle some sticky questions that might come up. Okay, get off my soapbox on that as well. All right, what about, I had this question about a year ago from one of our clients when President Trump was first implementing some of the rollback on the EEOC policies on transgender folks, and was doing other things that were viewed as perhaps not as friendly towards minority groups. What about jobs for disabled workers? There's a lot of places that have reserved jobs for disabled workers. That can be as simple as an employer who reserves certain jobs for folks who are on workers' comp, that, you know, the light duty jobs, or folks who have an ADA disability. It can also mean something broader in the sense of, and again, those of you who know I have adopted children, I have some that go to the Children's Institute. They will never, ever, ever have a job like you and I. What do they do though? They go to certain places and they love the work that they do, but they're much slower. They need more prompts and whatever to do the work. But there are places, and I don't just mean sheltered workshops, that will allow these folks to come in and do certain jobs for them. So far, we have not seen any targeting of those types of jobs at the federal level in terms of saying, hey, that's not appropriate. You have to open up job XYZ, not just to the disabled folks, but to Anne because she wants an easier, slower paced job. We haven't seen any of that happen. And in fact, we've seen the opposite at the federal level. The federal government still has special hiring methodologies for disabled folks. And in fact, prioritizes the disabled folks sometimes in terms of hiring. Usually when you see change, like at the transgender, with respect to transgender issues, you see it within the federal government first. And we've seen it in the military, right? We've seen them targeting that. We have not seen it with disability hiring in the federal government, which may give reassurance to folks who run organizations that are meant to help and hire disabled individuals that this may be okay. The only thing that we have seen that perhaps indicates something other than that is President Trump's comment about the California governor and how he wouldn't want somebody with learning disabilities running the nation. I'm hopeful that's just political rhetoric and not a sign of anything to come. So I think for right now, we're feeling pretty good about organizations that have jobs reserved for those with disabilities of some type. All right, that is everything for today. If you have any questions, feel free to submit them. We're actually done a little bit early, which means you can go sneak off to lunch early or enjoy the sunshine or whatever. Keep in mind, we have the FLSA and the handbook. I know that sounds boring, but we'll try to make it interesting. Webinars coming up in July and August, and then cocktails and compliance come out. As nothing else, you get a drink, and it's all good. Okay, enjoy the beautiful weather, and I will see you guys next month. Take care.